The next issue I want to address is I want to make a record specifically as it relates to the restraints that the Sheriff's Department utilized during this case, given a comment made by Mr. Brooks when the jury was coming out the very last time. I don't recall if you said something about a stun belt or shackles or something to that effect, but it was inaccurate. I have asked the Sheriff's Department to provide photographic documentation of the shackles that were utilized in this case. The parties will recall the tables look a little different now because there are no table skirts on them. On all defense tables in the secure courtroom, there is a ring. It's really more looks like a rectangle that is attached to the leg of the table, and an inmate who's in custody but in trial, a soft restraint system is utilized, primarily so it's soft and not heard, and then it's attached to the table so that it confines the inmate to a small area with that table. Obviously during the trial, Mr. Brooks was able to stand. His hands were free, but I felt it important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public, and that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
Why would that?
The record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So,
well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
there was no shock device.
It was a shock device. I was told it was a shock device,
Mr. Brooks.
And
that's
it was
why
covered
I'm
up.
making the record.
It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your characterization
I respect your
of
ruling,
those
but it
as,
should be noted.
Your
it should
objection
be
is
noted.
noted for the record.
It should be noted that I had a shock device on my ankles. That's fact.
It
It's
is
a
not
fact.
fact, sir.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to inquire about what's being put on my body. I was told that they were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The public doesn't deserve. The public deserves to know.
You've made a record,
the public deserves to know about
and
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this voltage.
It's absolutely false that you have a shock device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photographs.
Well, show
that
the
will be part of the record.
Where's the photographs?
And they will be
You just said they would be sealed. Why do they need to be sealed?
From public view.
Why
for the reasons that I've already indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right, so
can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today,
but
I don't
want to be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown. That's
not
why I had
right.
a chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else could be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your
Well,
characterization.
it's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need
There's
to move on
public.
to
There's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason
advising
why.
you.
And I always had the chair right here. Everybody that came in this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why
any
did I have a
further,
black cloth
any
in front of
further
the table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold me
letting
in
move
contempt,
on
that's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm gonna ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me then.
All right,
Remove me
Attorney
then. It's
Basie.
not gonna stop the fact that they need
All
to
right,
know that a shock device
he's
was on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll make the
That's
appropriate
fine.
findings.
Tell the truth, though, Your Honor. Tell the truth. I had a shackle.
Lieutenant.
I had a shock device
Captain,
on my
can I
ankles.
please see you? We're off the
For-
record.